Welcome, everyone. Very happy that you are all here for the copyright panel of Jazz Forum from Deutsche Jazzunion. I'd like to introduce you to our panelists. This is first Helga Trüpel, former member of the European Parliament for Bündnis 90 Die Grünen. Welcome, Helga Trüpel.
No. Hello, hi.
And there's Wolfgang Lackerschmid from Deutsche Jazzunion. Hi, Wolfgang. We have Philipp Rosset from GEMA European Affairs.
Hi, thanks for the invitation.
And there's Alicja Swierczek from European Affairs and Program Manager at European Composers and Songwriting Alliance. I hope I had that right. I'm not sure.
Yes, thanks.
There's also Micki Meuser, Chair of DEFKOM and Board of Deutscher Komponistenverband. Hello, Micki.
Hello, hello.
And our last minute guest, Tilo Gerlach, who is President of AEPO-ARTIS and Managing Director of GVL. Hello, Tilo. So I would like to start with a little recapitulation because a lot of our colleagues in the jazz world probably didn't follow last year's development. And so the European Parliament approved new copyright rules for the internet on the 26th of March 2019. And each country in Europe is in the process of applying this to their law. So what's new? What do jazz creators need to know about it? Could you give us a little insight? Maybe Helga could go first.
Yeah, thank you. And thank you again for the invitation. I would like to start with the general idea of this copyright reform. It was introduced by the Commission some years ago, and we had a thorough process of debating all the pros and cons for years. And then in the very end, the general idea was from the beginning and was decided then like this, to make the big commercial internet platforms like Google, YouTube, Facebook, and others go for licensing agreements with right holders and authors in order to put artists and authors in a better position. And that is not focused on very small entities or places like Tinder or Wikipedia, but really for the big commercial ones who communicate huge amounts of content to the general public without owning the rights. And we could not introduce a general obligation to go for licensing agreements because we know we have people in the marketplace on the internet who don't want their works obligatory to be licensed, for example, filmmakers. They want to decide on their own whether, for example, on certain platforms they have their films. But for a lot of other content, music, scripts, text, pictures, we want the big platforms to go for licensing agreements. That is the general philosophy of this reform, to put artists in a better negotiation position and in the very end to fight the value gap. That was the term throughout the political process in Brussels, in the European Parliament, that we realized more or less for a decade or two that the big platforms make a lot of money by using the work, the content of people who do that professional cultural work without paying adequately and fairly. And our aim was to put authors and artists in a better position. And especially now, what we did not, when we voted on this reform with the COVID crisis, we see that a lot of artists cannot perform live, and they cannot go for concerts. We cannot go, or we couldn't go for the theater, even for a certain time the cinemas were closed. So that means if streaming is going more and more on a global scale, we need urgently new mechanisms that the big streaming platforms and other platforms who use user-generated content do license the content. And then, of course, what you all know, what happened, the big companies themselves, especially the CEO of YouTube, Mrs. Wojcicki, said to the kids via YouTube, the European Union is going to close down your YouTube, your internet, and you have to go to the streets and to make a big fuss about it. And especially in Germany, that happened. And that we had the political constellation, the big internet monopolies on the one side, and pirates and youngsters and net activists on the other side, to be against this reform by framing the whole thing as a censorship machine and losing their normal behavior on the internet. From my point of view, that was never true, because there was very clearly written in the law that there is no general ex-ante monitoring allowed, but of course we want a clear distinction between neutral access providers and de facto content providers who misuse the creative work of others. And that in the very end, it was only a majority by 76 votes in the European Parliament to vote in favor of this reform. And what we see now in Germany, and we have the national implementation, as you said before, now going on, and the old fight, whether it's going to kill the internet, that's about censorship, whether the bad word about that upload filters will be introduced. They are there since 2 decades. It's not new that we have upload filters on the internet, but the anti-campaign managed to make that a very, very bad word and to give the impression that upload filters, more or less for the first time in history, would be introduced to bring down the freedom of the internet. And our narrative was to make the internet free and fair at the same time. And this cultural war is still going on. So that is what I would say for the first introduction.
Thank you very much.
Peter, darf ich an der Stelle kurz einhaken? Und zwar, es kann gut sein, dass wir nur deutschsprachige Gäste bisher da haben. Der Micki hat mich darauf hingewiesen, wenn jemand von den Zuhörern von euch nicht Deutsch spricht, if someone like from the other people who are watching this right now, if you're not speaking German, please write into the chat. Otherwise, we can do the rest of this talk in German. Is that all right?
It's all right.
Okay.
So I will continue in English for the moment.
Okay.
It would be interesting to know how the other European countries are dealing with this new European law. Do you have insights like on best practice and bad practice implementations of the law? Micki, maybe?
Well, it's all in a process in the moment. There's a tendency that France, Italy, and some countries are taking more or less the directive as it is. And some countries are, like Germany, are putting extras in, like in paragraph 6, bagatelles, trivia, exceptions that we need to talk about maybe later. And like Germany does even open an own legislation for it. It has a platform law now, and that is a new law, and it's not even copyright or author's rights. It's a completely new law, and we have to watch carefully what's happening. But I think Alicja could be best comment on that, because she's in Brussels, she's watching all this from the EXA European Composers and Songwriters perspective, And she knows much better than me from Germany. She has an overview of what's happening in all the countries. Maybe Alicja wants to say something.
Yes, thank you, Micki. Indeed, there have been just a handful of proposals so far. Most of the EU countries are still having this internal discussions and stakeholder meetings. So for now, there is no best practice example. And I have to say Germany is rather a bad practice example. So, which is unfortunate because they're the first ones to kind of like put some proposals on the table to see for the world. And unfortunately, the Commission has been kind of piggybacking on this a little bit. So they, the European Commission has kind of started with this consultation process on Article 17, how to best implement the technical measures to close this value gap. So what should the online platform providers, what should they do? What should the users do? And unfortunately, the proposal of the Commission, which is not final yet, so there's still some time to actually rectify this kind of draft guideline. So they have kind of proposed something that is alongside the German proposal, kind of giving a new concept of copyright material that may be infringing or may not be infringing, which is a weird category. How do you define uploaded content that may be infringing? So it's a weird process right now, and in Brussels, together with a lot of other stakeholders from the cultural sector, we're actually trying to talk to the Commission and convince them that they should provide better guidelines that are in the interests of music creators. So, yeah.
So I'm totally, how would I say that? As a musician, or as a composer that is mainly making music or composing music, it's quite hard to understand the processes of that. Is it already in place? I mean, I know that the GEMA has basically some kind of agreement with YouTube, and I see on my revenue that I got some kind of money from it, although the law is not really in place yet, which is very confusing for me. Could you maybe explain that, Philipp?
Yes, I maybe go one step back, because you asked what are the actual benefits of the new directive or of this Article 17 for creators. And just to explain it a little bit, I think this new Article 17, which was so controversial and deals with the responsibility of platforms, makes it clear that online platforms like YouTube fall under the copyright law and that they cannot hide behind. And as a consequence, they are responsible for the content on the platform and have to conclude licensing agreements with the right holders. And of course, this will strengthen the bargaining position of creators and their organizations, because until now, we have basically been negotiating with the platforms if they have to pay something at all. But now with the directive, it's clear that they have to pay something. But we are negotiating how much they actually have to pay. So we really believe that the directive will be a game changer in this respect, and will help to defend and to stabilize the value of music in the streaming market. And of course, this will also pay out in financial terms for creators in the long run.
And a question attached to that. Thank you very much, Philipp. So this new law is not only valid for composers, as I understand it, but also for performing rights. So what will change for the people who are in the G4L, Tilo?
Yeah, thanks. Let me first perhaps clarify that I'm not speaking on behalf of GVL here, because we are a joint society. Both performers and producers are members, and we are somehow very neutral in that perspective. I mean, we jointly think the liability of the platforms will improve the position of the so-called right holders. So in principle, for music will be paid more than it used to be. That's, I think, the positive aspect. For performers, and you are referring to GVL, the backside is that for these online rights, there's no collective management of rights via GVL. It's an issue of individual contracts between performers and producers, providing the share performers get. And that's a huge difference. And in the directive, there are nice attempts to improve the unfortunate situation of performers. I mean, I'm referring to these contractual provisions which are part of the directive. But these contractual provisions already exist in German law. I think the German law is more or less the model of it. And I don't want to criticize these provisions too much. It's good to have them. But to be frank, nobody is able to execute these rights. Because usually, if you sue your producer for a higher share, you're out of the business. And this is a problem which is not solved by the directive. And I mean, we do have three very important cases in Germany. Two are from authors. One is the cameraman of Das Boot, he is fortunately retired, so he is not depending on employment anymore. He got 100,000 of additional euros for his job because the share was unfortunately low. We also have a dubbing speaker, that's the dubbing speaker of Jack Sparrow in Pirates of the Caribbean, Johnny Depp. He sued the producer and got, I think, 8 times as much by court, but he was kicked out of the next movie, even with this very significant voice. And this shows that we need something else and then the individual bargaining, which is to the detriment of the performers. And that's why for performers on European level, we try to get an additional remuneration right collectively managed. It sounds very theoretical. We used to have that for rental, for example. I mean, GVL collected several million a year from renting of video shops. So you would have 2 sources of income as a performer. You get your individual share from your producer, and the platform would have to pay additionally collectively managed. And irrespective of your weak bargaining position, that's money you get. And that's what we are trying to get on national level when it comes to the implementation. It exists in Spain, for example. We have similar provisions in Italy already, and the directive in Article 18 provides the basis for this, and that's on the focus of the performers currently to get that additional remuneration right implemented on national level.
Thank you, Tilo. Are there more comments on the performing rights? Micki, maybe?
Yes, I can add to that. What Tilo is talking about is partly what we call in German Direktvergütungsanspruch. And it gives us the right and hopefully the remuneration in the future. But a very important point that is in the part between 18 and 22, I'm not really sure where it is that the new draft that came up the day before yesterday seems to take up our aim that we said we want to not get this blacklisting that people who win a court case and never do a job anymore. We want the right for an association to take a producer or a promoter or somebody who's not paying fairly to take them to court. In German Verbandsklagerecht, and that has been in German law until the year 2000 and has just silently been skipped, and we don't have it right now. That's why we have blacklisting, and you might win a court case but never do a job again. So if an association like your association, the Jazzunion, can do that, then maybe, hopefully, we'll have a situation where the player or the composer or the artist themselves doesn't have to show up. Mind you, it's very hard to hide because they have to, Tilo is a lawyer, he will explain that, they have to show what, that they have to prove there is a case for that. And then there's a contract maybe grayed out or blacked out, so you can't recognize the name of the artist, but I'm sure the promoter or producer will find out who it was. But still, we want this right for an association to take somebody to court, and maybe we get it.
Tilo wanted to say something.
Micki, you already mentioned the backside of it. I mean, it's a nice idea, not fighting for yourself, but having your federation fighting for you, but you have to expose yourself at a certain stage to prove the unfair payment. And that's exactly the moment where you are still in a weak bargaining position. That's why I personally think it's more a symbolic issue than really solving the problem. To act on an individual basis. It's still an individual case which is exposed to the producer with all the risks connected to it.
What we hope for, I mean, I take the expression of a black sheep. We hope for like a producer who does it with 3 or 4 authors or 3 or 4 artists, and then they can make a common case. That's maybe a different situation. And I already know a couple of cases in coercive publishing, in German Zwangsinverlagsnahme, that we do have frequently coercive publishing, at least in film music and in advertising, and sometimes with record companies. They give you a contract and they say you can sign this artist contract, but only if you go into our publishing company. And maybe you don't want to go into a publishing company, but you're forced to. And this is frequent practice, and we could just pick one of the producers who practices this and does it, and we would have like 10 composers who would be a victim of this, and maybe they could stand together. That's a case that I could imagine. We can't hear you, Peter.
I'm sorry. You just said that this new draft came out yesterday and you read it. So maybe for our viewers, it would be interesting how the process of that development of the law actually works.
I don't want to jump in for everybody. Maybe we can do this together.
Yeah, maybe Alicja could say something to that.
Well, Micki is referring to the German draft. As far as I followed the situation in Germany, there were several drafts to discuss, so they were open to the public, and the public could make comments, and basically that was published, I think, at the beginning of this year. And so I think the second one was around June, July, something like this, where the concrete proposal on Article 17 was published, and also more concrete proposals on the contractual provisions for authors and performers. So there was this consultation process that was closed, and now there is what Micki was referring to, this so-called Referentenentwurf. I think in English you would kind of say like a draft bill, or I don't actually really know. And again, there is now the consultation process, so it's open to the public again, and until the 6th of November, anyone can make comments to it, mostly associations actually.
Perhaps I can add, I mean,
I would like to add as well.
Sorry, the issue is that this draft comes from the Federal Ministry of Justice, and is not coordinated with the other ministries, not even with the other governing party, the Christian Democrats. So it's a very unique, specific approach from one ministry. And I think the input will not only be from the federations involved, but also from other ministries. And crucial, I think, is the Ministry of Economy in that perspective. And in the past, they were always much closer to the tech industries than to the creative industries. Unfortunate, and of course the federal minister of or state minister of culture will get involved as well. So I think it will be very interesting next weeks. I mean, the deadline is 6th of November, I think, for public, and they are going to present a governmental draft, so which represents all the ministries. That's the next step in January, to my understanding, January next year, or December even. Micki, more detailed information?
Maybe we hear Helga first, and I can say a bit about the timing.
You are muted.
Okay, sorry. Now? Yes, now it works, sorry. I would like to comment on the political process and not so much on the details. I think Micki and others may have more information on that. But because I was very much involved in the whole process in the European Parliament and with different member states, and especially, of course, the German situation, because I'm German. And what then happened with the first proposal, which was an unofficial draft by the Ministry of Justice, Lambrecht, that was in June, and it was only to figure out what are the reactions. And we had out of a sudden the same fight as we had before the vote in the European Parliament. We had the pirates, or the ex-pirate Julia Reda, totally against, saying, it's about upload filters, and the Christian Democrats with that proposal do not keep their promise to put the upload filters out. But what was, by the way, a very stupid proposal by Paul Ziemiak, because it was very clear that that is not possible to do it like this. And then they introduced in this proposal a lot of changes which were voted down in the process in the European Parliament. That was the Bagatelles case, it was pastiche without any restrictions, without payment, it was the pre-flagging, and to a certain extent, the first proposal by the Minister for Justice and Consumer Protection, what is important in this case, because they want to communicate from the Social Democrats' perspective that they are very close to the young generation and the influencers and users of YouTube, and therefore they want to be fancy and hip. That is the politics of Kevin Kühnert, who made the Social Democratic Party convention to be totally against the reform and then protesting in the streets in Berlin. And that is the same situation now. Interesting was that one of the co-presidents of the German Social Democrats, Saskia Esken, after publishing the first unofficial proposal by her party colleague Lambrecht was, yeah, we only go for so many upload filters as we need them. So that was a certain nuanced position what Esken did. And it's clear what Alicja said. Now we have the first official proposal, and which is still closer to the platform's interest and the user's interest than to the creators' interest. It's a certain sort of mixture now, but I think personally, and with some of the people who already commented publicly today, that what they do with this bagatelle clause, that is really much too big, and that is not serving the interests of authors and artists. So we are still in the process, and like Tilo said, now it's the question of the whole government and of all the stakeholders, whether there will be a certain change in the proposal, which then will be discussed next year in the National Parliament in Berlin. And the political situation is as follows, and that is to a certain extent different from Brussels, and therefore I have to, just to mention what happened in Brussels. We had more or less the PPE, the Conservatives, being in favor of the reform. It was the proposal in the first instance of Oettinger, Christian Democrat from Germany, then Gabriel, Christian Democrat Bulgaria, took over, and it was clear they were following the proposal to give more liability to the platforms. The Social Democrats were totally split, more or less 50-50 between the pirates' position and the platform liability approach. The Liberals were totally split. The Greens were, without me and some colleagues, were totally against the reform. The left-wingers were against, and the right-wingers were against because they think it's bringing down the freedom of the internet. So that was the political situation in the European Parliament. Now the situation in Germany is to a certain extent different. Between now, it's a political game between opposition and government. Government is so far split between Social Democrats and Christian Democrats, but Christian Democrats were not outspoken so far. But all the opposition parties, AfD, Greens, Liberals, and left-wingers are against the reform. So if there should be the introduction or implementation of this copyright reform, the government parties have to do it. And that is, even with the Social Democrats, it's very difficult because they are still split between the defenders of the reform and the enemies of the reform. And so now it will depend totally on the internal fight between Social Democrats and Christian Democrats, what will be the draft of the government, and then what will the parliament, together with the public debate, will do next year before the elections. And if they want to reach without paying money to the European Union's level, they have to finalize the whole process of implementing the law until the 7th of June 2021. But politically, we more or less have again the same fight as we had for 4 years now on the European level. We have it now on the national level. And in France, you saw what happened with the neighboring right for press publishers. Google was not ready to go for licensing agreements for the new right. And then the court in the end said, but you have to. And it's a very tough fight, not only with the youngsters and the net activists in the streets and on the internet, it's a tough fight between European sovereignty and interest and the big tech companies, the monopolies from the United States. And they make a power play out of the whole thing. And therefore, it's very, at least interesting what is going to happen and to what extent this global power play will affect in the very end the national implementation in Germany and in the other member states, because in Sweden, in the Netherlands, in Austria, you always have this art of fight on the question, what is the free internet or what is a free and fair internet? It's really a global, or at least the European and American big thing. In China, the situation to a certain extent, because of much more state surveillance, is different. But the cultural question, what do we consider as a good internet with a real fair balance between users, companies, and artists, that is not answered so far. The proposal by the European level and in the end the vote was a very clear stance in order to put artists in a better position, but the debate in society and politics, what should be the balance is not over. We are still in the process of debating that. And the drafts from the ministry so far, they reflect this political fight which is going on. That is my interpretation of the situation.
Thank you, Helga. Wolfgang wanted to say something.
Yeah, it's interesting that Google and all the big companies made it happen that it looks like a fight between authors and users, but the users are protected as well. Because the main thing is that if somebody pays, like YouTube, if they pay license, then the users are safe. If nobody pays license, everybody can sue the users for loading up something. And I'm discussing a lot with YouTubers and kids, and they don't know about that. So this is something what we have to communicate more.
May I say something? I'm really thankful to Helga for this very precise analysis of the political situation. It's very important to know that the work of the last 4 years that we did, and that came from our heart and is also sometimes emotional, and for us artists and creatives and authors, is risking our life or our the way we live, starts again and will keep us busy for at least another half a year. The worst case would be that there will be no agreement, that with saying it's a Corona time, that they can make it longer and they don't implement it after June, and it comes into a new government with maybe a different constellation. Let me finish this political dimension with what Tilo said before. We heard yesterday in a consultation that the German government plans to have the consultation finished by Christmas and have a voting in January. So it should be finished at the end of the year and voted in Parliament by January. And that maybe is the overview of the political side. Tilo, maybe.
Perhaps just to add, I mean, we are talking about copyright here, but I think we are also talking about, I think the status of the German state and taking decisions. And this is very concerning. It seems that because we have that so-called great coalition between the Social Democrats and the Christian Democrats, with that comparatively huge majority, there will be more or less no real discussion or influence of the parliament anymore. I mean, when you address members of parliament, of the Bundestag now, who belong to the governing parties, they have no position. They are waiting what the government decides. And I mean, this is really very bizarre, because we used to have a principle of common position in copyright, of consensus in copyright, where all parties more or less have been involved and were backing solutions. I mean, it's perhaps because we do now have one party which will definitely not back any constructive position in the parliament. But it seems that the parliament itself is not really taking into account in that legislative process. And they are the the legislators. That's why I think from a perspective, as a member of that country, a citizen, it's very concerning.
And if I may again, I'm sorry, I would like to lead this back to the jazz musicians that are inviting us, and maybe give them their perspective. It sort of tears my heart apart. Politically, you know, we're artists. We want to share things with people, and I'm maybe a socialist, but I see that the conservative parties are doing a better job for us right now. And the majority that Tilo mentioned could save us in terms of authors' rights in the end. But you as jazz musicians, you have a second level, that is that also conservative parties are also always on the side of the, and I only have the German word, Verwerter, of the people who employ you, your record companies, your managements and businesses instead of artists. So all the paragraphs starting from Article 18 to 22, which gives us a lot of rights, and which we've been talking before, and which gives you the right of transparency, the right of revocation, and that might be weakened when we get the conservative votes. So you have two sides that you have to see, which will influence your position. That is a position of players and also authors. You're both, you know, that's what I wanted to mention.
Thank you. Thank you for this analysis of the German process. And Alicja said that basically the German process is the other European. Did I understand you right? That the other European countries are waiting on the German process for their process to start? No, they have their own processes, right?
Exactly. But the European Commission is providing guidelines that should help other EU member states in implementing this Article 17. So some countries may be waiting for these guidelines, and but in the Netherlands, the process is quite, well, it has already started quite like some time ago. I think Poland just started now. And so, I mean, to go through all 27 countries in the EU is, well, yeah, it's not really necessary. Also, it's very different in every country.
But I would like to add to that, because it's true that the Commission is working on the guidelines, and therefore we had this stakeholder dialogue, especially on the controversial thing of Article 17 and how to implement it. But all the national states, the national governments have to make proposals, and then the parliaments have to discuss it and to vote on it, normally before June 2021, because that is the normal deadline. Now with Corona, we don't know, but that is the normal time frame of implementing this law. But another political comment. Now Germany has the council presidency. it's the biggest and at the moment the most powerful state with the presidency. So therefore the proposal, even if it's not a common government proposal, of course is important for the scenery in Brussels. On the other hand, in Brussels, Gabriel and others know that what Germany is proposing now is not really the spirit of the law on what we voted last year. And therefore, I heard rumors that the German proposal was very much welcomed in Brussels. Maybe Philipp can say more on that. I don't know, I'm not close enough anymore, but I think there are still a lot of actors in Brussels who know that the German proposal is not according to what we voted on the European level. And there still must be people, and Gabriel was very clear on that, the Commissioner for Culture and Education and so on, that he wants to have national implementations who really serve the spirit of the law and the reform. And maybe Alicja can tell us a little bit about the guidelines, because from my knowledge, it's not really finalized. And obviously a lot of member states have to a certain extent the same problems as we have now in Germany, because the conflicts of what is to be achieved with the reform are heavily debated all over Europe. And therefore, I would like to come back what Peter said before, to have more engagement in reaching out to deputies, to the general public, to the press, on the internet, to make clear what are the interests of artists in this reform. I think that is crucial, because the demonstrations in the streets in Germany, more or less a lot of people realized the interest of the so-called users and prosumers. But a lot of people did not realize what are the interests of artists and why liability of monopolies is so important. And from my point of view, it's still crucial that artists dare to speak out and reach out to the decision makers, and now in Germany, especially to the deputies who have in the very end to decide on the proposal by the government. And therefore, I think it's still time to do this job.
Thank you very much, Helga. Yes, Wolfgang, and then I want to change a little bit the topic.
Yeah, just a question to Helga. Is there a chance, if the German proposal is way beyond the European guidelines, that Europe can say to Germans, you have to do it better?
Okay, there is a political level where the Commission could say that. In the very end, and that was what the German music industry was discussing, if there would be an implementation that is against the spirit of the European law, you have to go to court. Because there is an assessment that the German proposal is not according to the international copyright laws. And therefore, I think if that would be the case, it's too early to say it, because we don't know what will be the result of the whole fight and the political process in the German Bundestag. But it's the European level of decision, what the parliament voted. Now it's the question of the national implementation, because it's a directive. And there is room of maneuver for national implementation. That was the sense of the whole thing. And it was decided very early because, for example, you have a certain tradition in France that is really different from Germany, and you could not compromise on certain things. And therefore it was not clear order de mufti from Brussels. The member states have to do it like this, but it's a directive, and that means there is national implementation. There are good reasons for that. There are bad reasons, but it's like this. And therefore, I think, and that is my assessment, until December or maybe January, we don't know with Corona and overall whether they will vote in January. Now is the time to argue and to reach out to the deputies, because the deputies in the very end in the German Bundestag make the majority, or they don't make a majority, or they make a majority for things we don't like. And therefore, I think now is still a window of opportunity to influence the debate publicly and on the national parliaments level. But, and you know, from the other side, to make the whole thing more complicated, it's not only, for example, artists and music industry who say, if the reform would be implemented like the first unofficial proposal of Lambrecht, it would not be in compliance with a lot of international laws on intellectual property, but you have the same fight from Poland and pirates to say, they say the upload filters are not according to European law and therefore we will go to court. So you have there the same conflict. Huh? The political conflict, of course, is reflected on the judicial level. And therefore the political process in Germany in the upcoming weeks is really crucial.
Okay, thank you.
Thank you very much. In the pandemic, we see an increase of streaming, and we have this new law not in place. Could you explain to the viewers how copyrights and performing rights are dealt with in this very moment, where all the jazz musicians in Germany and all the jazz musicians in Europe are streaming their concerts, or at least whatever, maybe 60% of all the jazz musicians are streaming their concerts. What are the revenues for them? Maybe Philipp could answer that, possibly. In the moment. You're not on.
Yeah, thank you. I think what we will see over the next months and years is that many new contracts actually will be concluded between platform and right holders. So this is, of course, will also benefit the jazz creators, I think. And of course, also existing contracts will be renewed. And as I explained earlier, with thanks to the strengthening of the bargaining position of the authors, I think that they will now be able to negotiate by better conditions in future contracts. So I think this will be one very concrete outcome, at least for our field, for the authors' rights part.
My question was for the status of the now. I mean, it is now that people are in the position that they have to stream concerts, or they feel they have to stream their concerts. How's the situation now?
I could say something.
Mm-hmm.
There's no change. The thing is that streaming services like Spotify have from the beginning been talking to Verwertungsgesellschaften, collective societies, and have recognized that collective societies will get a share and the authors will get a share. But this share is very small. It's less than 10%. And the other share is what goes to the labels or to the right holders of the master rights. That is 60% of the revenues of Spotify, and it hasn't changed. So if the DSM thing, the directive comes through, it, as Philipp said, it gives us a stronger position, but it's still maybe even a position where they put something between the performers and the authors, because Spotify might say, from the €1 or 99 cent that we get, we give you 72. This is Spotify gives 70 and Apple Music gives 72 to right holders. And you can split it as you like. And if the authors get stronger, then the performers get less. So this might be the case that happens. To make this clear, I offered to Christoph that I can show you a slide so you can clearly see where the money goes to in streaming, if that's interesting for you. Should I do that?
Sure.
It's just one slide, and I put on. Bildschirm freigeben. I think you need to activate that.
Yes, I can't see anything yet.
It says it's deactivated.
All right.
Anyway,
so it doesn't show any message here on my screen, okay. So
doesn't matter.
I can't put it in.
Basically what I said. Spotify gives 70 cents, which is also 70% of the money they make to right holders, and about 10% of that is going to authors, and about 60% of that is going to labels. And if you have a direct contract with Spotify, that might be enough. But if you go through a label and that gives you only 10% of what you have, which is the case with Universal, Sony, and Warner, you get like 6%. So this is the problem. If you hear somebody say we have so-and-so million streams and we only got 2,000 euros, then first of all, it's not clear, is it authors royalties or is it royalties for master rights? They never say that. But if it's master rights, then there's a label in between who gets a much bigger share. So this is your situation with streaming, and I'm afraid it won't change much.
But this is streaming of produced content, right? Does it make a difference if I stream a live performance or if I stream something that's pre-produced?
There is a difference on the author's rights because at least GEMA in Germany says if you stream a live concert, it's free, so they don't ask any money for it. And on the other hand, you don't get any money. That's one thing. And the deal that you have with Spotify, for instance, for a live concert, I don't know. The last thing that the directive might change is a shift if there's a necessity, there's an obligation for YouTube, which is in fact the biggest streamer in the world. They have 70% of the market. If they have to pay as well and get the same market position as Spotify and Deezer and all the others, when they're forced not to give anything for free anymore and have to pay licenses, then the competition might change and Spotify might be bigger or might get bigger. But with concerts, it's up to your negotiation what you deal with Spotify or with YouTube if you have a channel. That's not going to change through the directive.
Mm-hmm. And what's probably also interesting for the viewers is, I mean, we will probably see in the fall, if we see concerts, we will see a lot of hybrid formats where there's a limited amount of people which will go into the concert, but the concert will be also streamed digitally. How is that dealt with by the collecting bodies? I mean, I know that GEMA, for example, the revenues depend on the size of the venue. So if I have a big opera house with 15 people in it, does it still pay as much as it would before? Maybe Philipp could answer that, or Tilo.
I mean, I'm not an expert in GEMA, but I think we have to differentiate who has to pay and what does the members get. And of course, I mean, if there are different formats where you have a concert streamed directly without an involvement of a platform, then usually regarding the performance rights, it's up to you what your business model is. You can have subscription-based concerts where you have some provider and you share the subscription fee. And of course, when it comes to the platforms being involved, then usually it's this unfortunate bargaining power, irrespective whether it's YouTube or or Spotify. So this is really a matter of negotiations, and with regards to collective management, at least with the performance rights, there might be an issue for private copying. So when these concerts are legally copied, then you may be entitled to a share from the levy system. But this is very much depending on the distribution schemes of the collective management organizations. So in principle, I think collecting societies cannot really help to monitorize these concerts yet. I mean, with a GEMA, frankly, will also not be able to give more to you than it collects for this. And so there might be other models necessary for example, subscription-based virtual concerts.
Yeah, I mean, that's what I asked myself. I mean, that was during the lockdown. A lot of my colleagues did that. They went into a club and they streamed a concert. So I know the club has a, how do you call it? Like a
stream.
It has a stream, but it also has a contract with the GEMA where they pay a monthly fee, basically. And how is that dealt with? I mean, there were no people in the concert, but viewers. So
Philipp,
I don't know. Can somebody?
Or should I? Okay, as I'm on the board of GEMA, I can maybe answer that. It's very, very easy thinking. A club that still pays their subscription for a concert, GEMA will collect that subscription, and if they have a music list, they'll pay it out to the authors. The streaming side is also easy. You have two ways of streaming. One is on a platform and one is on a private website. So GEMA is in the situation, do they put an extra share on platforms or private websites for concerts? And in the first place, we said, no, we can't do that. Not in times when everybody has their economic problems. We can't go to clubs and say, listen, pay an extra on top for a private website, or pay an extra on top to YouTube, so we get an extra for the musicians, for the authors that their works are being played. So we are in this position that we can only say there's the concert situation with the concert subscription fees and royalties that you still get, and hopefully you get it. And there is, from the websites, some websites are already paying, but it's small money if they're private monies. And it's also small money from the platforms. So this is what you can get. Having said that, we have some, and this is also interesting for the jazz musicians, we have some promoters who are in favor of you, the jazz musicians, who are maybe from cities or from the States and who are willing to pay more and who address us and say, listen, we can only invite 30 people, but we know the poor musicians there, we want to pay more than we pay as the subscription for the concert. And this is the case for you as in jazz. This is more the case in classical concerts and in contemporary music, where we have that frequently. So GEMA is developing, it should come out very soon, a possibility for those promoters to pay an extra streaming concert service. Mm-hmm. This is the whole situation, but we can't go there and say no, because everybody's streaming, we want more money. This is just not possible.
Thank you. But there was a very, I always asked myself, but during the lockdown. Wolfgang.
Question to Micki. How about the concerts where nobody shows up? Because we have this limit about of 10 people in the audience. If it's less than 10 people in the audience, there's no GEMA.
Well, it's different. The concert still counts on the money side that's being paid out. On the royalty side, it will still be paid out, but the promoter might be free from paying. But we have lots of money where we don't have music lists. You know, we have in the small jazz club scene, only 50% of the promoters or the composers give us music lists. So GEMA doesn't know what's being played. So we have a lot of money that we don't know where to put. We don't know who is the author. So we are using this money to help small clubs. You probably know this, the promoter for a small, in the tariff K2 concert tariff, in small clubs to up to 200 people pays 24 euros for a concert. This is the GEMA fee. And if suppose you're the only composer of the night, only Wolfgang Lackerschmid's work would be played, then you would get out 104 euros. So this is a subvention we give in small clubs to make it attractive for composers to play there, and to make it easy also for promoters and help. So this is the same case if only 1 or 2 people are there. The promoter can make a little cross in a thing and say there was only 1 and 2 people. It's sometimes not even being checked if it's really, really true. And you still, on the composer side, you can still get the money.
Okay, thank you.
Another question that I had in my mind is that we see a lot of, I guess there are in every European country, there are schemes that try to help the musicians and the composers through these difficult times, and we get funding from certain places, and a lot of this funding will probably go into producing online content, which is a strange. I'm not sure if you can answer that question really, but are there alternatives to that? I mean, do you see alternatives to producing this content in the moment? Maybe this is more a musician composer question. Maybe Alicja and Wolfgang can answer that.
Well, if money is going into producing digital content or like concerts, I would put them on platforms that are specifically made to show concerts where you pay tickets to see that. Because otherwise, I mean, the revenue is just too small that you get out of that through collecting societies. On a general note, I just want to mention that right now, because we are in this pandemic situation, a lot of CMOs across Europe are rethinking their rates for digital content for like streaming concerts, more to the benefit of non-commercial music. So right now, these discussions are happening all over Europe. PRS in the UK is looking into putting different rates on live streamed concerts. Norway, so Tono, the name of the CMO in Norway, they are also looking into this. So right now there is experimenting with different fees for non-commercial music that is being live streamed. But other than that, I can only recommend to go on these concert platforms where you ask for tickets. Other than that, there is this new kind of method of paying artists through like stickers. So basically when you stream on YouTube, you can pay for stickers. I don't know, like €2, and then your comment will be featured next to the live stream of the concert. So something like this. But honestly, I mean, I guess it will be peanuts. So this is the only thing I can kind of say right now. You're muted.
Sorry, which platforms would you recommend? Which concert platforms would you recommend?
I don't want to make any like
okay.
advertisement for.
Can you mention 3 without recommendation?
Honestly, I have to look into this because
okay.
Yeah.
Thank you. Wolfgang?
I have to admit that I was very suspicious doing that, so I didn't do any streaming concerts. I also feel a little embarrassed if it's like playing for the head and selling a sticker or crowdfunding or whatever. I didn't like that.
May I make a suggestion? We have an amazing round of brain here, a European brain, political and experienced. Maybe the musicians among us, I offer to make a round and discuss all these specific German and distribution things. I'm open to that. And we now go maybe back to the directive or something that is on a European level. And because you have all these people here that you can ask and you probably won't have this knowledge anymore soon.
Sure. We could also probably at that point take questions from the audience, if that's okay with you. Yes, please, Tilo.
Sorry, I told you before I have to leave.
Yes.
But if there are any questions, just write in the chat, and I'm sure I will receive it. But just one final remark regarding these concerts, streaming concerts. One issue is the liability for good quality. I mean, that's an obstacle. If you really charge for that, then people expect a perfect sound. And this is, that's what I heard. It often is an issue that then the connection breaks, and I think there's some room for improvement to really come to a perfect offer. It's currently it's a bit unfortunate. You have often the gap between the quality and the fair price you deserve for your music. But have a nice final discussion, and thanks for being able to join you. Bye. Take care and stay healthy.
Thank you very much, Tilo. Okay, do we have questions from the audience? Could you write them in the chat? So far, no questions.
Until we have any questions, maybe I would count on the expertise of Helga there. Maybe we do a quick tour through the directive and above all about the problems that we have. Should we do this? And we tell you where are the big Baustellen and the big roadworks and the big problems that could occur.
Please.
That if you, and I would start with paragraph 5 and paragraph 6, which is prestige and also these trivia bagatelle exceptions. Just to let you know what's going to happen there is that music, 20 seconds of music are free from any authors and copyrights. 1,000 characters in books or lyrics, song lyrics or poems are free from any copyright. And pictures, photos and artwork up to 256 kilobytes, which is the format that Facebook uses anyway. So you can still see, in a very good quality, you can still see the picture. And this is something we need to protest immediately against, because this makes the lyricists of songs completely free of copyright immediately. I don't know if Helga can come, or maybe Alicia, but this is a real catastrophe, and it's an example what Germany is up to, because it's nothing like this is in the European directive. It's not European. The directive doesn't say there's the need for this. And the German Ministry of Justice comes up with this idea to please the consumers maybe, but it's there is no legal reason for it. Maybe Helga.
Yeah, that's very true that in the European directive, such exemptions are not foreseen. We discussed it for a lot of years, as you know, Micki, and then in the very end, we said that is much too dangerous. We were pressured by the so-called remix culture and free. We know it all over Europe, and especially in Germany, we have activists on that field. But on the European level, we said, no, that is opening a lot of dangerous doors, that artists, lyricists, journalists are not protected anymore by copyrights and even moral rights. And therefore, there was no majority for that. And the more it was interesting that in the first unofficial German draft that was included, my interpretation was that due to the remix culture demands and from people, net activists in the streets, they did it to please the young people, to show that the Social Democrats are very open and hip, and to please this part of the political spectrum. From my point of view, it was for very good reasons that we did not do this in the European process. I know I was pressured for years from a lot of people to be open on that. And of course, now with this bagatelle exemption, we have the remuneration included. But I think the bagatelle exemption is much too big. And that would really open the possibility without any restrictions to use or misuse the cultural work of a lot of people. So I'm really totally against. It's going much too far, and I'm there totally on your side, Micki. We have to go against this. And the same thing is with pastiche. You know, pastiche is a very French expression. A lot of people really don't know what it means. And I think even in the German text now, pastiche is used. And if you see the people who applauded this paragraph on pastiche, it was the pirate side and the activist side. And it was even without any remuneration in the first draft. And that, of course, is really opening the whole thing of sharing culture without any remuneration. I'm personally and politically totally opposed to that, because then a lot of cultural work would be without any fair remuneration and without impact of authors on their products. And that is what I really don't like. And therefore, on that, we have to reach out to the ministries of the Christian Democrats, the other social democratic ministries, and to the deputies to make them understand that that is more than dangerous. Because we had it in Germany that the people who applauded this first draft from Lambrecht, they were very clear why they were so enthusiastic about it, because that would enable them to do what they always wanted to do without any obligations to go for fair agreements, to go for licensing and all that.
Excuse me, would it be possible to explain the difference between the bagatelle and the pastiche? The pastiche is a comedy.
Two articles in the draft to have this so-called pastiche possibility, which, and it depends, of course, on the interpretation, but it's a very vague term that you can copy a style or what you ever say, what is a pastiche from your understanding. In the very end, you would have to go to court to clarify what is a pastiche or not. And with this bagatelle clause, it would mean that with remuneration, but 1,000 characters to 20 seconds for films, that would be for free. People can use it as they want, and authors don't have any impact on that anymore. And therefore I said, we discussed it for years, because maybe you remember the whole debate 10 years ago about a so-called flat rate for culture on the internet. And we had a lot of lawyers and experts in all the hearings on the European level, where we discussed, can we do it? With what proposals can we do it? Is it responsible to do it? Is it too dangerous? So it was not without debate to say we don't go for that exemption, because we open too much the ways of how the cultural consumption is now on the internet. But we know, and therefore I said it in the beginning, we have activists around this theme with this bagatelle clause, and they were demanding this move for years. They really wanted to have it for free, this way of dealing with the content of other persons. And then they say, okay, there will be a general remuneration. But I think it will not work, because if you take 20 seconds of a music piece, you know what it means. 20 seconds is can be the whole harmony of a thing. And therefore, I think it's really about expropriation of artists and authors when you go for that so-called bagatelle clause. And from my point of view, it's had nothing to do with bagatelle. It's really a big thing. And therefore, we have to oppose it. And my strategy now in the given situation is that we, so the people who are on that track, demand from the German government and the parliament that they really change this draft in order to make it congruent with the spirit of the European law.
It's very dangerous. I jump in here, you see it's getting emotional. It's very dangerous, like 20 seconds, maybe freeze complete TikTok. You know, they have these little clips, 20, 30 seconds. It's a complete Lex TikTok. They could, and also YouTube could limit their videos to 20 seconds, or the cat and the user-generated content. They could tell everybody, make it 20 seconds and it's free. This is very dangerous and we need to fight it. This is paragraph 6. And for you as jazz musicians, the paragraph 5 with pastiche, that includes the remixes, and that affects you. You have remixes, and we always had a fair use of remixes. If you remix somebody, you name the original author, or you give the author a share of your of the money you make. You make a contract and ask. But in the pastiche, in paragraph 5, and this is something you should, as an association, in my eyes, should protest immediately against. Remixes are free. This is just bad behavior. Any hip hopper and rapper can take a loop of your performance from somewhere, and I know you're great performers. They would like it, and if the better you record it, and the more money you put in, the more thankful they are, and they can take it and say, this is now my work. I don't need to give anything to the original author and the original performer. To me, this is just not necessary. We had agreements and it worked. We didn't have any limitations there. We had agreements. If you make a remix from somebody's work, you just ask them, they're glad to give you permission. But the net people said, oh, they put us as people who want to block everything and want to forbid everything. But we're not. We want to share, we want to do things, but we want to have a fair remuneration. We want some money from it.
Can I just ask, in the draft that it's out now, is the pastiche also limited to a number of seconds, or is it just, you can just use it?
General work.
Wow.
Yeah, and this affects you. You should protest there, and you have until the 6th of November to write directly as the association to the Ministry of Justice and say, this is why would you do it? It's already good practice. I can help you.
That's very good. Wolfgang.
So it's even getting worse. Micki, do you know how they deal, or Helga, how it's the deal with clips like Instagram? If it goes 15 seconds and the people splice it together and show a whole song in pieces. Would this mean that they don't need to pay for the whole song because it's all below 20 seconds?
Yeah, right. It's a platform. It's bagatelle. It's trivia, and it's not copyright. That's what they want.
Even if they show the whole song, but in little gaps.
So, sorry if I can say something on this one. So you mentioned the platform Instagram. Is it on Instagram? Okay, because as GEMA, we have a contract with Instagram, and as soon as we have a contract, or as there is a licensing agreement between the rights holders and a platform, the the bagatelle exception will not apply any longer. So we have to keep it in mind. And as was said before, I mean, the de minimis or this bagatelle exception is of course very problematic. I agree with what has been said, but at least it is accompanied by a remuneration. So I'm not sure from a GEMA, pure GEMA perspective. I mean, we have licensed all the services. So I'm not sure if it makes a big difference for us from an author's rights point of view.
Philip, it might in the future with new negotiations. They might say, here, we have this directive.
And I perfectly agree that it's problematic. I mean, because it's simply not compatible with European legislation, with the InfoSoc directive, which is based or which includes a closed catalogue of exceptions, and this de minimis or bagatelle exception is not part of it. Yeah. But just for the understanding, I think if there is a licensing agreement, the exception does not apply.
And the pastiche would also not apply?
The pastiche is a different case. I mean, with the pastiche exception, we have the problem that it's required by the directive. You know, in the directive we are talking about, it clearly says users across Europe have to be able to rely on a pastiche exception. And we don't have it in Germany, so it has to be introduced in some way. And then probably the best thing that we can ask for is for a remuneration, a broad remuneration. Not only for online, as it is suggested right now in the most recent draft, but also for other uses, like when it's used on TV programs, for example. So that would be a first thought on that.
I would like to come in at that point because Philip is right. We had to put the pastiche exemption, but it's not clarified whether it should be without remuneration. From my point of view, it must be with remuneration.
Absolutely.
Analog and digital. But to make you understand why it is in the law, that was due to political pressure and the question of majority, because the main rapporteur, Axel Voss, had to work on a coalition to have a majority in the very end for the law. And without this pastiche, there would not have been a majority in the Legal Affairs Committee. So that is the background why it's written there, but it's vague. Huh? And therefore, at that point, it very much depends on the national implementation, not to widen it anymore, but to make very clear. And therefore, I completely share what Philip said. There must be a remuneration obligation, analog and digital on pastiche. And it's true what you said as well. If there are contracts or an obligation or licensing agreements, then the bagatelle clause is not applying anymore. But on the other hand, if there would be this new paragraph with the bagatelle clause, then the question is whether the platforms can misuse it not to go for licensing agreements because they say there is other possibility. I don't know, maybe you are more firm on that, what it could be as a consequence. But my interpretation so far that this reform proposal of the Social Democrats is open on that is due to the political pressure from the young generation to open this. And therefore, I think it's again the question of political communication now, that artists and jazz musicians and all of the affected creative workers have to make understand the people who decide now why that is not in their interest to make it as it's now in the proposal of Lambrecht. That is what I would say at the given momentum is crucial, that you make people understand what is at stake concerning your interests. Because the other camp is very vocal on that.
Thank you very much. We do have a question. Are there specific names of government bodies that we should be addressing, that we should write to? Is it the MPs? Is it our MPs of our area? Or is it, if we are individuals, that is? Who should we contact? if it's not our association, but if we just individual artists, should we write to our MPs, or who should we go to?
So I think you can, of course, you can do it on a personal level. Then you should write to the deputies in the German Bundestag who deal with that in the upcoming weeks. So that is legal affairs, it's the speakers for digital affairs, the speakers for cultural affairs, the group leaders. So because all the people have to deal with the process. On the Länder level in Germany, the prime ministers, of course, they are part of the political public. But I think now in the given momentum in Berlin, you have to address the ministries who work on the government proposal, and then you have to deal with the deputies, because the deputies in the very end, probably in January, as Tilo said, they have to vote, and then you have a majority or you don't have a majority for a certain text. That means you have to influence the text, and you have to influence with your argumentation the deputies to make them understand what is your interest and why you want to have a fair law concerning payment on the internet.
Thank you very much. I think we already passed our time. It was incredibly informative for me, at least, and I hope for everyone that watched. Thank you so much for taking part, and thank you so much for taking the time. And I hope we see us soon in real life. Thanks a lot, everyone.
Thank you.
Bye-bye.
Thank you.
Bye.